I accept.
Sometimes what's not said is more important than what is said.
Sat with, and I think
Good morning. I'm David Barish, Chairman of the Pennsylvania Gaming Control Board, and as always, I ask people to put their cell phones and electronic devices on silent. Today with us, Fred Strathmeyer. I never know who's going to be there. Hi, Fred. Representing Russ Redding, Secretary of the Department of Agriculture, Jennifer Langen, representing Joe Torsella, the State Treasurer, and Christine Heidingsfelder, representing Secretary of Revenue, Dan Hassel. Thank you all for coming and participating. Commissioner Knodel is participating today by telephone. Good morning, Obi, if you're not on mute. He's on mute.
Good morning, Chairman.
Okay. Quorum of the members being present, I call the proceedings to order. First order of business, the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. By way of announcements, the board held an executive session yesterday, Tuesday, December 18th, to discuss personnel matters and to conduct quasi-judicial deliberations relating to matters the board's going to consider today. First order of business is public hearing involving Stadium Casino LLC's petition for approval of corporate restructuring. As always, before we begin, Mr. Stewart, I'd ask everyone who's going to speak today, please state and spell their names for the court reporter prior to the presentation, and I'd ask that all non-attorney witnesses be sworn at this time, if you have any.
Yes, Mr. Chairman, we have one. Go ahead, stand.
Robert Norton. N-O-R-T-O-N. I do.
You can begin.
Thank you, Mr. Chairman. May it please the board, good morning. My name is Mark Stewart, S-T-E-W-A-R-T, and Mark with a K, with Eckert Siemens for Stadium Casino LLC. With me is Rob Norton, President of Cordish Gaming. And as was previewed at the board's November 28th meeting, internal changes have been proposed for Stadium Casino LLC. And we are before you this morning seeking approval of a corporate restructuring that will leave Stadium Casino Baltimore Investors, or the Cordish companies, as the sole member of Stadium Casino LLC. The petition and a supplement filed of record address the details of the proposed restructuring. But briefly, Stadium's two members, Stadium Casino Baltimore Investors and Stadium Casino Investors, worked effectively together throughout the licensing phase in this matter and in overcoming multiple legal challenges to the board's license award. Changes in the law brought about by Act 42, however, meant that the stadium partnership was no longer necessary for its casino project to proceed. The partners determined that both casino projects, both the Category 2 and the Category 4 project, would be facilitated and would move forward most efficiently as solo efforts. As such, they came to an agreement to restructure Stadium Casino, with Stadium Casino Baltimore Investors being the sole member. A confidential supplement including 3 exhibits has been filed of record in this matter. Exhibit 1 includes the agreement and documents related to the proposed restructuring. Exhibit 2 depicts the ownership as it would be post-approval if the board deems it appropriate to approve it. And Exhibit 3 establishes the availability of funds to close on the restructuring. As is evident from the petition and the supplemental exhibits, this is a completely internal restructuring. No new partners are being introduced, and all of the same individuals who presently own Stadium Casino Baltimore Investors would be the owners of that entity post-approval. And with that background on the proposed restructuring, I would turn it over to Mr. Norton for his comments and an update on the Category 2 project.
Great. Good morning.
Morning.
It's Rob Norton, Norton. Since our last presentation to the Commission, we've continued to work on all cylinders in preparing this project for construction. Included in the project, including completing the project drawings so that we can put them out to formal bid, continuing our outreach efforts to the MBE, WBE, and LBE vendors in the community, and establishing our contractors. I'm happy to inform the Commission today that we have actually received our building permits. They are in hand, and we look forward to moving forward expeditiously on starting the construction on this project and bringing Live and the Live brand casino to the Philadelphia market.
As a final point, we wanted to address the issue of a change of control fee as it relates to the corporate restructuring. Our petition sets forth our argument as to why imposing no fee would be consistent with the intent of Section 1328, and we won't repeat that argument before you this morning. We'll rely on the petition. To the extent that a fee is deemed appropriate or required by the board, we would request that it be set at a de minimis level, which would be consistent with the board's past precedent in cases such as the Mount Airy restructuring, which involved a $1 fee. We have here, as was noted, a completely internal restructuring. The parties to Stadium Casino had already paid a full $50 million license fee only approximately 12 months ago. And as was testified before you at the November 28th hearing, the project investment has increased in the Category 2 project by approximately $250 million. So with all of those factors considered, we would urge that the board exercise its maximum discretion, reduce the fee as little as possible, even to $1. And with that, we will, other than moving our exhibits 1 through 3 into the record, we would stand for questions from OEC or the board.
All right. Can exhibits 1 through 3, so moved. Comments or questions from Enforcement Council?
We don't have any comments or questions at this time. We'd like to make a statement, a recommendation to the board.
Please.
Yeah. James Armstrong for the Office of Enforcement Council. Chairman Commissioners, the Office of Enforcement Council, along with the Bureau of Gaming Operations, the Bureau of Investigations and Enforcement, the Bureau of Gaming Laboratory Operations, the Bureau of Licensing, the Office of Diversity, and the Office of Compulsive and Problem Gambling have reviewed and consulted extensively on the petition filed by Stadium Casino LLC for approval of corporate restructuring, after which OEC filed an answer in this matter requesting that the board order the implementation of certain listed conditions if it was so inclined to grant the relief requested in the petition. As a result, the Office of Enforcement Council has no objection to the approval of corporate restructuring for Stadium Casino LLC pursuant to the petition and subject to the proposed conditions outlined in OEC's answer filed on December 5th, 2018, and any additional conditions imposed by the board. Thank you.
Thank you. I presume you have no objections to the conditions that are being proposed?
No objections, Mr. Chairman.
Any other further comments in response to OEC at this point?
No, sir.
Okay. Questions or comments from the board at this time?
Just one, it's great to hear this progress. And as you reported, you were very happy to report getting the permits and the work you've done. I suspect you were giddily very happy to report that because it has taken a long time, and it's time to proceed apace.
Okay, we're going to take this up when we get to the Office of Chief Counsel's portion of the agenda. Thank you for showing up.
Thank you.
Thank you.
Next order of business, we have Harrah's petition for approval to modify their gaming floor. And again, I would ask that everyone who's going to speak, please spell and state your name for the court reporter prior to your presentation. And I would ask at this time that all non-attorney witnesses please stand to be sworn. Petitioners can begin.
Members of the board, my name is Bill Downey, D-O-W-N-E-Y. I'm with Fox Rothschild on behalf of Chester Downs and Marina LLC, doing business as Harrah's Philadelphia Racetrack, Casino and Racetrack. Mr. Chairman, members of the board, we're before you this morning on a petition to modify the gaming floor, which includes a slot reduction beyond.
Mr. Downey, could you do me a favor and introduce the individuals who are with you today?
Sure.
Thank you.
To my left, Chris Albrecht, General Manager, Senior Vice President of
Thank you.
Harris Philadelphia. Albrecht, Albrecht. And to his left is N. Lynn Hughes, Hughes, Vice President and Counsel. Also with us in the back, we have our Regulatory Compliance Officer, Marissa Stagg, and Joe Tyrell, who's our Vice President of Government Relations.
Thank you. Please proceed.
Mr. Chairman, we're before you today because we're outside of the Executive Director's threshold for approval of the slot reduction. This morning, Mr. Albrecht is going to make a presentation describing the changes, the determination to engage in reduction, and then we'll come back. I have a couple of additional matters to discuss with the board.
Okay, please proceed.
Mr. Chairman, members of the board, very excited to be able to speak to you today about this opportunity for us to make a modification to our gaming floor that we believe is going to help enhance our customer experience. This is going to allow us to really complete the third of what are 3 projects we are doing in the back of our casino, which is a very underutilized space in our facility. And towards the end of the presentation, you'll see what those changes are and what we're looking to do back there. So as it relates to our slot business in Harris, Philadelphia, you can see over time as increased supply, competitive pressures continue to come in, the amount of gross terminal revenue we're able to drive at the facility has continued to go down. Over time, we have received some relief for the amount of slot units we have, but as you can see, as it continues today, we continue to have really more supply than we need for the demand that we have, and that we believe that space could be better used to enhance the revenue overall in the facility. Despite these challenges we face, we do continue to put significant investment into our slot business at Harris, Philadelphia. Almost 2 years ago, we redid the entire carpeting and reconfiguration for the facility last time we did do a slot reduction. Just recently, we invested in brand new slot chairs, which had not been changed out in the entire history of the property, and those are actually going in as we speak. We continue to add new machines to the floor on an annual basis. We are one of the properties in all of our organization that receives the most new slot machines on an annual basis, so we do continue to invest in the product at the facility. We also put a lot behind making sure we have the latest leased product, as those remain to be some of the best units out there available to us, and we invest significantly in that. And we also continue to market very heavily to our slot customers to encourage them to come visit us at Harris, Philadelphia. So continuing to put a lot behind this business, again, despite some competitive challenges. You can see here, our occupancy has continued to go down really over the last 4 or 5 years. Even after our previous reduction, we still sit just under a 17% average occupancy for our casino floor, so a significant amount of our units on a regular basis continue to be underutilized or unused. Even on our sort of peak days and peak hours that we see in our business, there's still a significant amount of units that go unused. On our busiest day in the past year, on March 3rd, in our highest hour, we still had over 870 machines available for customers to use. So even when we are at our busiest, we still have, again, a lot more supply than we need, and we believe, again, that space can be better used to draw folks into the facility. So what we're asking you today here is to consider a reduction of another 187 units to our floor, which is currently at 2,450. The games we're looking at, and again, we'll show you a map here on the next slide, are towards the back of our facility, a very, again, underutilized smoking section of our floor that we believe, again, we could do better use with that space. And these games are fully owned by us, and again, have been with us for a long time. Out of these 187 games, 164 are going to be coming out of smoking. So as a output of this, we are going to be reducing the amount of units on our casino floor that are dedicated to smoking, so will become more of a non-smoking experience for our slot customer. We also don't believe there's going to be a lot of impact to our staffing model or really a lot of work to get this done. And still at 2,263 machines after this reduction, we'll still be have the 6th most amount of units in the Commonwealth of Pennsylvania. So I apologize for how this map may look, but if you can notice to the right, that's the front of our casino, sort of laid out there. And the area we're referencing is essentially in the exact opposite corner, the exact back there to the left where that red box is that we're looking to do. And when I mentioned at the start that this was the third of 3 projects, above that is where our new sports book is going. That is under construction now. And then we are also relocating our poker room from the level below this floor up to the floor up there. So with the new sports book, the relocated poker room, and then moving out these slot machines in the space, we are going to put another amenity there that we believe will enhance that whole experience in the back. And all these experiences are going to be non-smoking in the back of the facility. So dialing in a little closer to that space, again, the relocated poker room going up top
Excuse me,
left.
can I may have misunderstood. You said all that area in the back
Yes.
is going to be non-smoking. You're only referring to the place where you were pulling out the 167 machines,
I'm
correct?
also referring to the fact that the sports book and the poker room themselves are also
Poker room
non-smoking.
too?
Yeah, so all of those spaces are non-smoking as well as the space we're pulling out. Yep.
Thank you.
So here you can see, again, the poker room up there in the top left, the sports book in the top right, and then this new space we're looking to carve out is going to be an entertainment space. I apologize that the drawing's a bit rudimentary here, but the concept is a partnership with Topgolf, and we are going to be putting in 3 different what they're called entertainment or gaming bays where folks can do some simulated playing of different games. The area will be amenable to us serving food and beverage and other things in the space as well. And so we're very excited to offer this as a amenity to our customers who are also going to want to enjoy the sports book and the poker room and any other folks within the facility. So this really allows us to bring 3 new amenities that will bring people through our casino, which is a challenge right now to get people to come all the way through. And we believe the combination of these 3 new assets will really allow for, again, some increased play in the overall facility as well on slots and tables as well. So that concludes my formal presentation, but happy to answer any questions you may have.
Questions or comments from the Enforcement Council?
Morning, Mr. Chairman and members of the board. Michael Rowland, ROL A&D with the Office of Enforcement Counsel. We do have a couple questions for Harrah's staff. Draw your attention to slide number 2 to begin with. And at the end of the graph, it appears that the gross terminal revenue here has really begun to level out over the last year. So the question is, why is now the right time for a slot reduction?
Sure. So we have been able to hold on and level out this year. We've had some increased competitive pressures in the last really couple of years, and then there are some also continuing to come here into the future in the Philadelphia market, both within the Pennsylvania side in Philadelphia and as well as the New Jersey side. So we believe that not only are these pressures happening to us right now, but they're going to continue into the future. And so we're setting ourselves up for what we believe will be revenue stabilizing and revenue saving opportunity for us. Given the fact that our slot supply is still so heavy, we're trying to add new amenities to keep that number stable.
On slide number 3, and specifically bullet point number 3, you state that over 300 new games have been added since 2017. Did those 300 games replace outdated games, or did those 300 added games increase the overall complement available to us?
Those 300 games, I obviously don't have the full detail in front of me. Those 300 games more than likely replaced underperforming units across the floor and were put into various locations around the facility.
Okay, then on slide 5, and specifically in the section you labeled the impact box, bullet point number 2, you state that there will be minimal staffing impact. If your petition is granted by the board, would there be any reduction in the number of employees at Harrah's associated with this slot reduction?
None contemplated at this time, but obviously the normal course of business and volumes always dictate that we will make adjustments to our staffing level.
And draw your attention to slide number 6. You framed out in a red box the area of the gaming floor that will be affected by this reduction. And then on slot 7, you indicate that this will be the new entertainment space. Approximately how many square feet is this area in question?
I apologize, I don't have that, but I will get that over to you.
Would Harrah's have the necessary space needed to implement the identified changes to the gaming floor without reducing slot machines?
We would not.
And if the board should grant Harris' petition today, when do you anticipate the slot machines would be removed and the floor modifications complete?
The slot removal would happen fairly quickly. The modifications to the space are in concert with the other two projects, so they're all kind of working concurrently, but all of the projects are expected to be completed by the middle of Q1.
And to be clear, is the purpose of slots removal to add table games or to implement sports wagering?
It is not. It is for a non-gaming amenity space.
If your sports wagering area was in a different location of the facility, let's say near the racetrack or near the pari-mutuel area, would you maintain the need to remove slot machines as opposed to replacing them with more popular slot product?
Can you please repeat that?
I can. If your sports, we're looking at sports wagering now, if your sports wagering area was in a different location of the facility, and as an example, closer to the racetrack or in the pari-mutuel area, would you still maintain today that there's a need to remove the slot machines that were part of your petition as opposed to just replacing them with newer product?
Yes, I would. Again, I still would like to remove these on the main floor and to create a more greater experience for our guests on the main casino floor.
I don't believe we have any additional questions.
Are you going to have a presentation?
The Office of Enforcement Counsel does not have a public presentation today. However, we respectfully request that should the board grant Harris' petition to modify its gaming floor, that the approval be made subject to the 8 conditions set forth in OEC's December 6th, 2018 answer. And obviously, we're available for any questions the board would have.
Do you have a comment?
Yeah, Mr. Chairman, we do have one point of order we want to make. In the course of reviewing the petition that we filed, staff determined that there was an error in one of the paragraphs that we offered. I want to clarify that for purposes of the record because it does relate to a data point that is described in the petition. In paragraph 10B2A, we make the statement that, as I've done in the past with the format of the petition, we offer you a bunch of data points that describe our occupancy and through a bunch of different lenses. In this one in particular, we're focusing on our occupancy during the highest average day during a trailing 12-month review. In the course of analyzing that, we also provide you the highest hour that occurs during the highest day. That's not the highest hour during the year, just the highest hour during that highest volume day. We then try to turn that into better English, if you will, and describe to you what that means in practice. And what we said in the petition in that respect was that during the peak hour of the peak day, approximately 68.4%, or roughly 6 out of every 10 machines, was available for play. That should not have been a reference to the peak hour during the peak day. It should have been a reference simply to the peak day, the average availability. Okay. In fact, during the peak hour of the peak day, 38.1%, or approximately 3 machines, were available for play. Importantly, this is the only place in the package that was submitted or reviewed by staff that contained that error. Each of Exhibits B, C, D, E to the petition contain literally thousands of data points. All of those are clean. All of the material reviewed by FIU and OEC are otherwise clean. We just wanted to make the record clear on this point.
Okay.
Otherwise, the other thing I'd like to do procedurally is move the petition into the record.
Do you accept that explanation?
We do. OEC concurs. We've discussed it with FIU, and that's accurate.
Before we move anything, are there questions or comments from the board at this time?
Yes. So again, speaking on the Racing Commission's behalf, again, we look at reduction of slot machines as a concern, and I just want to go on the record of that. And as council pointed out, with the leveling of the revenue, this becomes even greater concern for the Racing Commission and how it affects the Racehorse Development Trust Fund. So I just wanted to make sure, Commissioner, that we put this on the record. Thank you.
Commissioner Jewell.
Yes, I'm interested in your comment on the change in demographic or customer profile, if any, that will be effectuated with these changes, both as to your sports bet and as to the golfing venue, or however we can describe it, and the implications of that for you.
Yeah, I mean, ideally for us, we're bringing a new customer into the facility. We obviously haven't opened sports betting yet at our facility, but what we've seen at our properties in New Jersey, stopped over at some of the recent openings here near me in Philadelphia, it seems that we're getting a new customer base into the property through sports betting. So we hope that that is going to be the same case for us, and that this Topgolf concept would obviously support our current customer and encourage them to come visit us more and continue to play slots and tables, but also a newer customer that might want to do sports betting and the other amenities. All these things that we do for the back of the facility there are to drive customers to play our traditional slot machines as well. So while the GTR has flattened for us, we do want that to go up. And so doing this, we believe, will help combat and hopefully increase that as well.
You sort of have to pass a lot of slot machines on your way to
That's part of the plan, yes, exactly right.
You don't have big signs directly. Any other questions or comments at this time? Mr. Downey, did you want to move some things into evidence here?
Yes, Mr. Chairman, if we could move the presentation into the record.
So moved.
Thank you.
Any further questions or comments by either?
Additional. Thank you.
Okay. This one will also be voted on when we get to the Office of General Counsel later. Thank you for showing.
Thank you very much.
Thank you very much. Next order of business will be Valley Forge's petition for a sports wagering certificate. Again, everyone who's going to speak today, please state and spell your name for the court reporter prior to your presentation. And Mr. King, if you would have all non-attorney witnesses, please stand at this time to be sworn in. You may begin.
Thank you, Mr. Chairman, members of the board. Good morning. Adrian King from the Ballard Spar firm here on behalf of Valley Forge Convention Center Partners, LLC. First of all, happy holidays to everyone on the board and the staff. It's been an action-packed year. Here today in connection with the petition for sports wagering certificate, and joining us today are our partners from FanDuel, and I'll introduce them in 1 second. As we've noted before, we're partnering with FanDuel with respect to both sports wagering and then interactive gaming. If you recall from our presentation in October on the interactive gaming certificate, we briefed you with respect to FanDuel. So we're going to try to avoid some overlap from that presentation, which I'm sure everyone would be very, very happy about. Let me just quickly introduce everybody who is here. To my immediate right is Dave Zerfing, who you know, who is on site, the Valley Forge Vice President and General Manager. Next to him is Bill Wright, who is our Senior Vice President of Operations with responsibility for Valley Forge out of Las Vegas. Not here today, but I just want to note part of the team on this project is a gentleman by the name of Bob Scucci, who's the Vice President of Race and Sports Operations. He has 27 years of experience in the field. And then next to Bill is Christian Janensky, who is the Chief Legal Officer of FanDuel. And next to him is Jonathan Edson, who's the Senior Vice President of Business Development. The org chart that you see sort of next to those names on the slide, you saw that before, again, from the interactive gaming petition. So with respect to interactive...
We don't have any slides yet.
Oh, I'm sorry.
It's okay.
I have it over here, but I don't know why it hasn't transferred up there. Well, I do have, I think there are paper slide decks in front of you.
Okay. Oh, we've got them.
Would you like to move to the paper?
No, yeah, we've got the hard copy. Fine.
Okay, so on slide 3, that org chart is basically applicable to both interactive gaming and also mobile and internet sports wagering. And we'll be talking both about internet and mobile sports wagering, but also a retail version of sportsbook at the property. And with that, I'm going to turn the presentation over to Jonathan. And Jonathan, you'll just let me know, or I'll cycle through the slides for you.
Jonathan Edson, EP is David S-O-N. Mr. Chairman and members of the board, thank you very much for.
I think you need to bring your microphone closer to you or something.
Is that working better?
Much
All right.
better, thank you.
Thank you. As Adrian said, we will review two things today. One, a little bit of background on FanDuel and our partnership with Boyd, and then more specifically our plans for sports wagering, both online and at Valley Forge Casino. Just to start out, and I know you've heard some of this information before, so if I'm moving too quickly, my apologies. FanDuel is one of the largest interactive real money gaming operations in the United States. We operate fantasy sports across the country, including here in Pennsylvania. We offer a business through TVG for wagering on horse racing, and we offer sports wagering, both retail and online in New Jersey, as well as interactive casino in New Jersey. If you turn to the next slide.
Slide 5.
Slide 5, excuse me. Just one thing of note. Although we operate as an independent entity, our majority shareholder is a company called Paddy Power Betfair, who is one of the largest operators of online gaming worldwide. And you can see from the map here all the different locations and where they are. It's really across the globe. Turn to the next slide. Just a little bit more of a perspective on the brands. I mentioned each one of these each of these business lines that we're in. On the sports wagering side, we're currently operating in New Jersey, as I mentioned. We're also operating in West Virginia. On the fantasy sports side, we're in 42 different states. Horse racing, 33 states, and then casino in New Jersey as well. On the next slide, we talk a little bit more about our parent company. As you can see, they're large, the large global operator, as I mentioned. They're doing $15 billion in stakes on sports wagering every year. That's globally, that's not including the United States. They have a very strong heritage of offering retail in-person sports wagering with 600 different locations in the UK and Ireland. It's a very large company, 7,000 plus employees. That's the parent, not FanDuel. And again, just the global footprint. We're licensed in 12 different countries. As for our company itself, we have leadership who come from both the gaming heritage, consumer products heritage in the United States, and I think both in terms of the expertise that we bring to offering gaming and just the overall professionalism and experience of the management team, we think we're well positioned to be operating with our partners Boyd here in the state of Pennsylvania. On the next slide, just a sense of the different other entities that have partnered with us in the past. We, coming from the fantasy sports side of the business and now on the sports wagering side of the business, we've allied ourselves with several of the major leagues and several professional sports teams as a way of enhancing the experience that our customers have in participating in those different products. We also, as clear from the fact that we're here today, are partnered with Boyd Gaming to work with them on sports wagering and casino across the United States in every place that they're licensed. We also have successfully partnered with other provider of gaming services, in New Jersey and in other states across the United States. The next slide, you'll see that we have had some initial success in New Jersey, which is very gratifying, and I think from the perspective of the state of Pennsylvania, the two things that I would note is that it shows that the product that we're offering appeals to the customers, should appeal to the customers in Pennsylvania as it appeals to the customers in New Jersey. Also, it shows the willingness that we've had to invest significant dollars in marketing the product, which we would also expect to be spending here in Pennsylvania with local media outlets, et cetera, and introduce the product and to replicate this success if possible. On the next slide, just wanted to note that we are successfully operating an in-person sports book now in New Jersey, and very large, 10,000 square feet. We have 30 different teller windows. It's 120 staff, and it is quite an operation. And I think as our first sports wagering operation here in the United States, we feel like it's been very successful, and that we're operating at these kinds of volumes, I think gives us confidence and hopefully would give the board confidence that we'll be able to do that successfully in Valley Forge as well. The following slide with the timeline just is to present our hopes about how the project would proceed, of course, assuming that we're granted a license from the state of Pennsylvania. We're in that process now, which is in the top, moving from the top left to the top right. Below that, you'll see that the execution pieces that we're doing, we are planning the construction, ordering hardware, et cetera, and, hopefully sometime in 2019, based on your approval, we would begin operating both online and in person. So now to the specifics. You can see this is our diagram of what we would be doing at Valley Forge along with our partners at Boyd. It would be an 1,800 square foot facility, 7 teller windows, 6 self-service terminals, seating capacity for about 30, and then about 20 different staff people at peak. If you're familiar with the Valley Forge property, it will replace what is now the food court. So as you enter the property, right to the left is where the sports book would be located.
Smoking or non-smoking? David, I don't actually know the answer to that.
We were looking at smoking.
Oh, okay.
I'm sorry? Smoking.
The next 2 slides are just some renderings of what we think the sports book will look like. It's sort of attractive space, modeled closely on sort of what we have done at the Meadowlands and seen success with plenty of viewing opportunities with televisions, FanDuel branding, etc. You'll see that on the next slide as well. In addition to the Valley Forge location, we will be offering a mobile sports wagering platform as well. We've designed it to offer the most in-depth product mobilely that people can use to bet on U.S. sports. We offer the most comprehensive payout options of anybody in New Jersey at the moment, and we've also designed it to sort of allow us to transparently comply with all the regulations that we would be under. Next slide, just to say that I think we're excited with our partner Boyd to become part of the Pennsylvania gaming community. We see here great opportunities both to bring employment in the construction phase and on an ongoing basis in the retail sports book, and that, hopefully that we would also be delivering millions in tax revenue over time, to the state of Pennsylvania, and that most assuredly we are committed as FanDuel and with our partners Boyd to responsible gaming at the heart of what we do. With that, I think I'll turn it over to Adrian to talk a little bit about that subject and some of the other regulatory.
Thank you, John. I want to give these topics, obviously, appropriate focus and respect, but these are slides that we've presented before. Obviously, everything that we will be doing with sports wagering will be appropriately integrated into the responsible gaming program. We'll be working closely with board staff to make sure that we are fulfilling all of our obligations, again, both with respect to the retail side of sportsbook and any of the online options, just like we discussed when we were presenting on interactive. And then, obviously, everything that we're going to be doing in terms of the rollout and the operation will comply with all of the regs and requirements of the board. There will be obviously giving the board the insight and access to the program through the platform that's going to be provided through IGT. And obviously that's very important from your regulatory perspective. And also just a last comment on ensuring that all best of class practices are used with respect to protecting customer data, and obviously that also goes to the integrity of gaming overall. So we just wanted to touch upon those issues. It kind of goes without saying, but it's so important that it shouldn't go without saying. So wanted to make sure we touched on that. With that, our presentation is concluded, and we'll be ready for any questions at the appropriate time.
Enforcement Council, questions or comments?
Good morning. Ashley Gabriel, Gabrielle, with the Office of Enforcement Council. And the Office of Enforcement Council does not have a formal presentation. However, with the board's permission, we would like to make a statement and recommendation.
Please.
Thank you. The Office of Enforcement Council, along with the Bureau of Casino Compliance, Bureau of Gaming Operations, Bureau of Investigations and Enforcement, Bureau of Gaming Laboratory Operations, Bureau of Licensing, Office of Diversity, and the Office of Compulsive and Problem Gambling have reviewed and consulted extensively on the petition filed by Valley Forge to conduct sports wagering and for the issuance of a sports wagering certificate. OEC filed an answer in this matter requesting that the board order the implementation of certain listing conditions if it was so inclined to grant the relief requested in Valley Forge's petition. As a result, the Office of Enforcement Council has no objection to the approval of Valley Forge's petition to conduct sports wagering and to the issuance of a sports wagering certificate to Valley Forge Convention Center Partners, LLC, subject to the proposed conditions outlined in OEC's answer filed on November 29, 2018, and any other conditions the board may impose. The Office of Enforcement Council is available for any questions you may have.
Thank you. Questions or comments from the board? Commissioner?
Thank you. Following up on your answer to Commissioner Logan about the decision that the sports book be smoking, am I correct in assuming that the current food court is non-smoking?
No, the current food court is smoking.
Oh, the current food court is smoking.
Yes.
Interesting. Thank you. To the Office of Enforcement Council, remind me how the sports books are treated in terms of gaming floor and not gaming floor, and the ratio of smoking and non-smoking in our regulations?
The sports book area would be considered part of the gaming floor. Pursuant to the Act, 50% of the gaming floor cannot be smoking. So we would have to compare that to the remainder of the gaming floor. Now, I know that in some, if the board is so orders, we can consider that sports book area a separate part and make it 50% smoking or non-smoking.
So going back now to Harris, so you are reducing your non-gaming floor area, reducing your food court to replace it with more gaming floor square footage. What is your current ratio in terms of smoking and non-smoking in your facility?
We are at 50-50.
So based on Enforcement Council's answer, you as part of your proposal here, you would have to be coming to the board again to ask for a exception or whatever is the right thing to expand beyond 50%? What am I missing?
No, there won't be any exception. The sports wagering area will be 50-50. The sports wagering area will be 50% smoking, 50% non-smoking. Despite what their plans are, we're going to make it 50-50.
Oh, okay. And that's because they are at the max already?
That's because that's
the way we're doing it.
That's the way we're doing
it. Okay.
If I could, just to clarify, when you say that's what the law requires, right?
It is what the law requires. I mean, even if you take into consideration the gaming floor is currently 50-50, so now you're adding more gaming floor space. That space is going to be 50-50.
Can I just
yes, go ahead.
Try to get some clarification on something? I'm not in favor of one or the other, but there's another approach, right? I guess the other approach that would comply with the law would be if they wanted to make sports gaming completely smoking, they'd have to take a portion of the rest of their gaming floor and make it non-smoking to keep them at 50%.
That's an approach, but that's not one that I think that we would approve.
No, I'm trying to understand, though, just the legal side of it. The end result is they have to make sure they don't go above 50% on the entire designated
gaming floor space.
Correct. But the particular places on the gaming floor that are smoking versus non-smoking is a matter in which we exercise discretion.
Yes.
Is that fair?
Yes.
Thank you very much. I'm sorry, Kathy.
No,
More, you have more on that?
No, thank you. Not at this time.
Anybody else? Questions? Yes.
I have one comment. Of course, with Act 42, the so-called access fee or cover charge or whatever it's called was taken off. And I've noted, especially for you all at Valley Forge, you have moved in a very robust fashion to take maximum advantage to the benefit of your business and ultimately the benefit of the citizens of this Commonwealth in tax revenue. So it's, I've noted that, and I've liked what I've seen.
Thank you.
Any other questions or comments from the board? Any comments
just
from you?
Just,
Or
very quickly, on the smoking issue, I just want to reiterate our commitment to obviously be in compliance with the law and to work with the staff and OEC as necessary to be in compliance. We will work constructively. With that, just administratively, I'd like to move our presentation into the record, and if that's approved,
okay, so moved.
I will close our presentation and respectfully request approval of our petition. Thank you.
We will take this up in the Office of General Counsel section a little bit later this morning. Thank you very much. Hi, Danette.
Good morning.
Good morning. Director of Human Resources, Personnel.
Good morning, Chairman, member of the board, members of the board. The Office of Human Resources has one motion for your consideration today relative to the hiring of one individual. Josh Wiscora has been selected as a casino compliance representative for Mohegan Sun Casino under the Bureau of Casino Compliance. Mr. Wiscora has completed the interview process, background check, and drug screening and is recommended for hire by Acting Director of Casino Compliance, John Santel. Unless you have questions, I ask the board consider a motion to approve the hiring action as indicated.
May I have a motion?
Mr. Chairman, I move that the board approve the applicant for hire as proposed by the Human Resources Director.
Second.
All in favor?
Aye.
Aye.
All opposed? The motion's adopted.
Thank you.
Thank you, Danette. Doug Sherman, Chief Counsel.
Good morning, Chairman, members of the board. The board has 6 petitions before it for consideration today. 3 of the petitions have just been heard a short time ago. The remaining 3 will be decided based upon the record by agreement of the parties. And in each of these matters, the board has, in advance of this meeting, been provided with all documents filed of record. The first petition before the board is that of Stadium Casino, and it's their request for approval of the corporate restructuring. As you heard, the restructuring would allow Stadium Casino Baltimore investors, which is the Cordish Group, to acquire the present 50% ownership interest of the Stadium Casino Investors LLC, which is the parks side of the equation. Final result would be that the Cordish Group or Stadium Casino Baltimore investors would own 100% of the project. Stadium's requested that certain of the information contained in the petition be maintained as confidential. OEC does not object either to the restructuring or the confidentiality. It would be appropriate to now consider a motion to approve the request.
Any questions or comments from the board at this time? Hearing none, may I have a motion?
Mr. Chairman, I move that the board approve Stadium Casino LLC's petition
for approval of corporate restructuring and request for confidentiality as described by the Office of Chief Counsel and with the conditions to be outlined in the board's order. I further move that Stadium Casino LLC be assessed the change of control fee in the amount of $100,000.
Second.
All in favor? Aye. All opposed? The motion's adopted.
Next is Chester Downs and Marina's petition to modify their gaming floor. As you heard, the change would remove 187 slot machines from the gaming floor. It would reduce the gaming floor by about 7,000 square feet and reduce the smoking area of the gaming floor by approximately 2,000 square feet. These changes, as you heard, will allow Chester greater flexibility in managing its gaming floor, including the creation of a sports book and a new non-gaming sports entertainment option. Additionally, Chester has also requested that the board delegate to the executive director the ability to approve minor modifications of the gaming floor during the post-construction phase of its modifications, and to permit Harris to provide quarterly operational plans after completion of the construction phase. The Office of Enforcement Counsel has proposed several conditions which were outlined in their answer, and we would be in agreement that those conditions are appropriate, and the matter is now ready for the board's consideration.
Questions or comments from the board? Hearing none, may I have a motion?
Mr. Chairman, I move the board approve Chester Downs and Marina LLC's petition for approval to modify the gaming floor as described by the Office of Chief Counsel and with the conditions outlined in the board's order.
Second.
All in favor?
Aye.
All opposed? Motion's adopted.
The next matter is Valley Forge Convention Center Partners petition for the sports wagering certificate, which the board just heard. I want to address one issue that came up there, and that's with regard to the smoking area. It's our position that the smoking area of the sports betting area is to be considered separate from the general gaming floor where slot machines and table games are played, such that the area of the sports book cannot exceed the percentage of smoking area permitted under the Clean Indoor Air Act. And to make it perfectly clear, it's our position that you can't look at the other floor of the casino and, for instance, make the sports book completely non-smoking and use that number to then increase smoking on the other area of the floor. Clean Indoor Air Act is very clear that the gaming area of the primary gaming floor cannot be more than 50% smoking, and no game playing can be used in shifting between the areas to influence another one.
Okay, I'm sorry. I know you're trying to clarify it. In my mind, you muddied it a little bit for me with your example.
I have that ability.
Yeah, well, you're also having a bad voice today, I can understand. You said non-smoking in the sports book when I thought I heard their intention was to make it smoking.
Correct. The point being that if they would say we're going to make the sports book completely non-smoking, they can't then reallocate the smoking portion to the primary casino.
So this is the inverse of the question I asked Cyrus before. I got it.
Right.
Okay.
So each section will be looked at independently with respect to the percentage of smoking allowed under the Clean Indoor Air Act.
Good. Thank you.
With that clarification, as you heard, board's being requested to approve a sports wagering certificate to be issued to Valley Forge. In doing so, you're not authorizing the immediate commencement of sports book, but rather this is the first step in then allowing the process to move forward under board staff oversight. Of course, the casino would have to complete a test period, as we have recently been undergoing. And with that, Valley Forge has also requested that certain portions of the record be maintained as confidential, and that being security plans or surveillance issues. We would agree that that should be maintained as confidential, and the matter is ready for the board's consideration.
Are there any further questions or comments from the board on this matter?
I do have a question because I'm about to make the motion. The conditions to be outlined in the board's order will include the enunciation you've just made of the smoking analysis?
We can assure that it will.
I have a motion.
Mr. Chairman, I move that the board approve the Valley Forge Convention Center Partners LLC's petition for sports wagering certificate and request for confidentiality as described by the Office of Chief Counsel and with the conditions to be outlined in the board's order.
Second.
All in favor?
Aye.
All opposed? Motion's adopted.
The next matter pertains to a request for removal from the self-exclusion list. This is filed by an individual by the initials LB, and I understand that the individual is present and would like to address the board. By way of background, in October of 2018, LB filed a petition for removal from the self-exclusion list. On November 9th, 2018, LB and the Office of Enforcement Counsel filed a joint stipulation of facts, which is before the board. As provided in the stipulated facts, LB placed himself on the self-exclusion list in March of 2009 for a period of 1 year. After the expiration of that 1 year period, he removed himself from the list, and then in June of 2011, entered Sands Casino, met with the casino compliance representative, and again placed himself on the self-exclusion list. This time, it was for the lifetime. LB's request for removal from the board's list states that in 2011, he decided to place himself on the self-exclusion list at a time when he was getting ready to place 3 children through college and wanted to ensure that any disposable income or assets would go to their higher education and he would not use them at the casino. He further states that since that time, he has completed the process of the children's education, has relocated out of state, and is preparing to start retirement. The stipulation also says that during his retirement, he would like to be able to travel with his wife and patronize casinos throughout the United States. And while the Pennsylvania self-exclusion list only applies to casinos in Pennsylvania, a number of our casinos do then use our list to exclude patrons from their other sister properties in other jurisdictions. As stated, the individual is present and would like to address the board.
Thank you.
Morning.
I have a brief statement.
1 second, please. Should I be swearing him in? And if so, since we're operating anonymously, how do we do that?
I think the individual, we know who he is, and I think if he stands, he can swear to tell the truth. And
okay, let's do that.
Record.
Let's do that. Thank you. Now you can proceed, sir.
Thank you. My name is L.E.B. I formerly resided in the Commonwealth of Pennsylvania and had requested to be placed on the self-exclusion list in the Commonwealth of Pennsylvania on March 13, 2009. I have since relocated to Georgia and recently built my retirement home near Atlanta. I've been on the self-exclusion list for close to 10 years now. Back in 2009, I made a decision that I thought was correct decision for me and my family at that time. That decision was going from a 1-year enlistment of self-exclusion to an entire lifetime ban. I truly never realized the full impact of what I was signing up for. The mistake I feel I made was taking an extreme approach to gambling by signing up for a lifetime ban when I should have only signed up for 5 years. As I stated, I will have been on the self-exclusion list for close to 10 years come March 13th, 2019. I honestly would like to right the wrong I made 10 years ago.
Can I ask a question? You said, I'll be on the list for close to 10 years. Are you saying that in March of 2019 it will be 10 years?
Yes.
Thank you.
I'm sorry. In October of this year, I decided to reach out to the PA Gaming Control Board and ask for special consideration to have my name removed from the self-exclusion list. I have been working through Ashley Gabriel, Assistant Enforcement Counsel, to assist me with this request. I flew from Atlanta to Harrisburg last evening so I could personally deliver my petition to the Gaming Control Board in person. That's why I'm here today. I do acknowledge that I had requested this lifetime ban and signed the necessary documents. However, I never realized the full impact of that decision. At the time of me signing these documents, I was raising a family and had to be very disciplined with any extra money. I took an extreme approach to gambling. There were many casinos being built in Pennsylvania at that time. I lived about 15 minutes away, about a 15-minute drive to the Sands Casino in Bethlehem, and I was actually one of the first persons to sign up on the self-exclusion list at Sands. I simply didn't want to lose money gambling it away when I really needed when I needed the extra disposable income for college savings. My life has changed over the past 10 years since I first got in contact with the PA Gaming Control Board. I accomplished what I had set out to do, and that was to pay for my 3 children's higher education through college. All 3 of my kids have successful careers after graduating from Penn State University. I relocated to Georgia, built a home, and is starting to plan for retirement. I would like to have this opportunity to occasionally enjoy the fun of gaming at casinos with my wife, friends, and family, instead of not being able to set foot in one. I truly never realized at the time of my signing that the self-exclusion ban would include nearly all casinos in the United States. Lastly, I'm asking this board to allow me a second chance and to please remove my name from the self-exclusion list and lifetime ban for the reasons I stated. Thank you very much for your consideration.
Other questions, comments from the board, please? Oh, please.
Thank you. Thank you for making the effort to come. I do have a few clarifying questions because from my reading of the record, I didn't count close to 10 years. So I'm trying to figure out how you got to the 10 years. Are you going back to when you first signed up for the 1-year exclusion and putting all that time together?
That is correct.
Okay. And you're saying that during that time you considered yourself self-exclusion even if there was, oh, I don't even know, was there a gap between when you signed up for the 1 year and then when you signed up for the lifetime?
I would have to say that there probably was a gap, but I'm not sure.
Okay.
I'm just going off the fact that, as far as I'm concerned, I've been on the self-exclusion list really since March 13th of 2009.
Okay. And I do know that some casinos, if you are on another jurisdiction's exclusion list, they will exclude you from all of their properties.
Correct.
But some casinos don't. Have you attempted and been unsuccessful to go into a gaming facility, or have you not really tried because you knew you were on this exclusion list?
I have not tried. I haven't even gone on the property. But I did do a little research before coming in here, and I know that there's a couple very large companies that, like, that owns Harrah's, for instance. They have a lot of casinos. So if, for instance, if I wanted to go to Las Vegas, I couldn't even stay in a hotel in Las Vegas because the majority of the properties all are with the self-exclusion.
I did also review your paperwork when you signed up for the lifetime self-exclusion, and I noticed that there are questions at the end of that form that ask you, do you need information on addiction treatment or addiction counseling or referrals to addiction places, and that on your forms they had been checked off no. So could you explain kind of what your mindset was at that time and why you checked off no?
Never felt I had an addiction to gambling. This had nothing to do with it. I think people sign up for self-exclusion for several reasons. In my case, it was a money thing. And I just felt with the casinos coming into Pennsylvania that I just didn't want that attempt to go. You know, I wasn't a big gambler, to be honest with you. So, you know, I did that, and now I'm at a different point in my life, several years later, looking forward to retirement, and really would like consideration to be removed from it so that I could game again once.
And just one more question. Prior to your signing up for the first time for the 1-year exclusion, had you been a patron of Pennsylvania casinos, and if so, how how often did you go?
I did. I was. I probably, going back 10 years, I'm trying to think. It wasn't that often because I couldn't even afford losing $200 at the time. So
Okay.
it wasn't
Four
very
kids in
often.
college, right?
What's that?
Not with having to put 4 kids in college, you couldn't afford
Yes.
to lose 200.
Okay, thank you. I have no more questions, Mr. Chairman.
Are there other questions? I have a clarifying question. There are a number of Indian casinos in Georgia, Mississippi, Florida.
There are none at all anywhere close by in the South.
Oh, really?
Mhm.
Okay, because I was thinking that they generally do not tie into the bans in other states. Are you familiar with that?
I'm not, but I can, just a little bit of work that I did look into the companies that do own. There's a few companies that own the majority of the casinos, and they all have the self-exclusion.
No, I understand.
And it's kind of a difficult spot for me to be in because I can't go onto the property. And I think you can understand where
I
I'm
understand.
coming from.
Just
and that's
trying to
why I'm here
clarify the
today.
question about the Indian casinos. This time, I think we'd like to take a short recess to think about what you've had to say
Thank you
today.
so much.
So we're going to take a break for a few minutes, unless there's any other questions at this time. Thank you.
Hello?
Okay, we got you reconnected.
Okay, thank you.
Regarding LEB's petition for removal, are there any further questions or comments from the board at this time? Hearing none, is there a motion?
My understanding, based on your testimony, is that you've been self-excluded from Pennsylvania casinos since March 13, 2009. That's correct? Mr. Chairman, I move that the board approve LEB's petition for removal from the PGCB voluntary exclusion list effective March 13, 2019.
Second. All in favor?
Aye. Aye.
All opposed? The motion's adopted. Thank you for coming.
Thank you very much.
Thank you. Moving ahead.
Yes, the next petition is Richard Lenscold's request for removal from the board's involuntary exclusion list. In October 2016, Mr. Lenscold, who was 19 years old at the time, entered Sugar House Casino by providing a false identification to security. He was on the gaming floor for about an hour and a half and gamed during that time. Subsequently, when discovered, he was evicted from Sugar House and issued a citation. The Office of Enforcement Counsel subsequently entered into a consent agreement with the individual, placing him on the board's involuntary exclusion list until at least his 22nd birthday, at which time he could petition the board for removal from the list. Mr. Lenscold, who is now 22 years of age, is requesting removal from the list. OEC has no objection, and the matter is ready for the board's consideration.
Questions or comments from the board? Hearing none, may I have a motion?
Mr. Chairman, I move that the board approve Richard M. Lenscold II's petition for removal from the PGCB involuntary exclusion list as described by the Office of Chief Counsel.
Second.
All in favor? Aye. All opposed? The motion's adopted.
And the last petition before the board is Roderick Perry's request to be removed from the board's involuntary exclusion list. On July 31st, 2014, Mr. Perry assisted a 20-year-old in accessing Valley Forge's gaming floor. Mr. Perry was evicted from the casino. Subsequently, the Office of Enforcement Counsel filed a petition to place him on the board's involuntary exclusion list. On September 17th, 2014, the board placed Mr. Perry on the list for at least 1 year from the date of the order, at which time he could petition the board to come off the list. It's now been over 4 years since he was placed on the involuntary exclusion list, and he is now requested to be removed. There's no evidence that he has violated the board's order, and OEC has no objection to the request. And that's the petition now.
Thank you. Any questions or comments from the board? Hearing none, may I have a motion?
Mr. Chairman, I move that the board approve Roderick Perry's petition for removal from the PGCB involuntary exclusion list as described by the Office of Chief Counsel.
Second.
All in favor?
Aye.
All opposed? The motion's adopted.
Next, presenting withdrawals and reports and recommendations is Deputy Chief Counsel Steve Cook.
Good morning, or afternoon, whatever. The board has received several unopposed petitions to withdraw the applications or surrender the credentials of the following individuals: David Smale, Salvatore Basile, Joseph Feldman, and James Gundy. The Office of Enforcement Counsel has no objection to any of these petitions, and as a result, if the board were to grant same, they'd be doing so without prejudice to each of these persons. And these matters are all ripe now for the board's
Any
consideration.
questions or comments from the board? Hearing none, may I have a motion?
Mr. Chairman, I move that the board issue the orders to approve the withdrawals and surrenders as described by the Office of Chief Counsel.
Second.
All in favor?
Aye.
All opposed? The motion's adopted.
Next before the board today is one report and recommendation received from the board's Office of Hearings and Appeals. This report and recommendation, along with the complete evidentiary record, was provided to the board in advance of today's meeting. Additionally, the person that is the subject of this report and recommendation, Tyler Creniti, has been notified that the board would be taking the matter up today and that he had the ability to come and briefly address the board. Briefly, in January of 2016, Mr. Creniti was issued a gaming employee occupation permit and worked as a table games dealer at the Parks Casino. On February 28th of 2018, the Office of Enforcement Counsel filed a complaint to revoke Mr. Creniti's gaming employee occupation permit based upon recent criminal convictions. Specifically, he was convicted of a felony robbery offense stemming from an altercation with his ex-girlfriend that led to him taking her wallet and leaving the scene. And additionally, there were 2 cases in which he was found guilty of felony criminal trespass after entering his parents' home, violating 2 protection from abuse orders. As a result, Mr. Creniti has now been convicted of 3 felony offenses, and as a result is no longer eligible to hold a gaming employee permit. A hearing was nevertheless held on August 21st, 2018. The Office of Enforcement Counsel put the evidence of his convictions into the record. Mr. Creniti did not appear, and as a result, the hearing officer's recommendation is that his permit be revoked.
Questions or comments from the board? Hearing none, may I have a motion?
Mr. Chairman, I move the board adopt the report and recommendation issued by the Office of Hearing and Appeals regarding the revocation of Tyler Creniti's gaming employee occupation permit as described by the Office of Chief Counsel.
Second.
All in favor?
Aye.
All opposed? Motion's adopted.
That concludes the matters of the Office of Chief Counsel.
Thank you. Sue Hensel, Bureau of License.
Thank you, Chairman Barish and members of the board. Before the board today will be 1 interactive gaming operator, 2 sports wagering operators, and 1 video gaming terminal establishment applicant. In addition, there will be 559 principals and key gaming and non-gaming employee applicants. In addition, there will be the consideration of 2 gaming service provider applicants. The first matter for your consideration is a conditional interactive gaming operator license for Rush Street Interactive PA LLC. Rush Street Interactive PA LLC is a Chicago, Illinois-based interactive gaming operator. It plans to provide an interactive gaming platform and other services on behalf of at least 1 interactive certificate holder. Under the board's regulations, the board may issue a conditional interactive gaming operator license provided the applicant has submitted a completed application, agrees to pay a $1 million licensing fee prior to the issuance of the license, and the Bureau of Investigations and Enforcement does not object to the license. The applicant satisfies these criteria. Prior to this meeting, I provided you with an order to conditionally license Rush Street Interactive PA LLC, and I ask that you consider that order.
Enforcement Counsel has no objection.
Questions or comments from the board? Hearing none, may I have a motion?
Mr. Chairman, I move that the board grant Rush Street Interactive PA LLC's conditional interactive gaming operator license as described by the Bureau of Licensing.
Second.
All in favor?
Aye.
All opposed? The motion's adopted.
Next are 2 sports wagering operator applicants for conditional licensure. The first is TSG Interactive U.S. Services Limited, which is a New Jersey-based company. The second is OpenBet Technologies Limited, which is a London-based company. Both companies propose to operate sports wagering on behalf of at least 1 sports wagering certificate holder. Under the Gaming Act and board regulations, the board may issue conditional sports wagering operator licenses, provided the applicants have submitted completed applications, agree to pay the $50,000 licensing fee prior to issuance of their licenses, and the Bureau of Investigations and Enforcement does not object to the licenses. The applicants satisfy these criteria. Prior to this meeting, I provided you with orders to conditionally license both TSG Interactive U.S. Services Limited and OpenBet Technologies Limited. I ask that you consider the orders, starting first with TSG Interactive U.S. Services Limited.
Enforcement Counsel has no objection.
Questions or comments from the board? Hearing none, may I have a motion?
Mr. Chairman, I move that the board grant TSG Interactive U.S. Services Limited's conditional sports wagering operator license as described by the Bureau of Licensing.
Second.
All in favor?
Aye.
All opposed? The motion's adopted.
And next, OpenBet Technologies Limited.
Enforcement Counsel has no objection.
Questions or comments from the board? Hearing none, may I have a motion?
Chairman, I move that the board grant Open Bet Technologies Limited's conditional, I should say, sports wagering operator license as described by the Bureau of Licensing.
Second.
All in favor?
Aye.
All opposed? Motion's adopted.
Also for your consideration is the conditional VGT establishment license for Lancaster Travel Places LLC, which is located in Rocks, Pennsylvania. Under the Gaming Act, the board may issue a conditional establishment license provided the applicant has never been convicted of a felony, is current on state taxes, has submitted a completed application, and has not been convicted of a gambling law violation. A preliminary review of this applicant indicates it meets these criteria. I ask that the board consider a motion to approve the conditional VGT establishment license for Lancaster Travel Places LLC.
Enforcement Council has no objection.
Questions or comments from the board? Hearing none, may I have a motion?
Mr. Chairman, I move that the board grant the conditional video gaming terminal establishment license for Lancaster Travel Places LLC as described by the Bureau of Licensing.
Second.
All in favor? Aye. All opposed? Motion's adopted.
In addition, there are temporary principal and key employee licenses for your consideration. Prior to this meeting, the Bureau of Licensing provided you with an order regarding the issuance of temporary licenses for 1 principal and 5 key employees. I ask that the board consider the orders approving these licenses.
Enforcement Council has no objection.
Questions or comments from the board? Hearing none, may I have a motion?
Mr. Chairman, I move the board grant the temporary principal and key employee credentials as described by the Bureau of Licensing.
Second.
All in favor?
Aye.
All opposed? Motion's adopted.
Next are gaming permits and non-gaming registrations. Prior to this meeting, the Bureau of Licensing provided you with a list of 461 individuals to whom the Bureau has granted temporary or full occupation permits, and 85 individuals to whom the Bureau has granted registrations under the authority delegated to the Bureau of Licensing. I ask that the board consider a motion approving the order.
Enforcement Council has no objection.
Questions or comments from the board? Hearing none, may I have a motion?
Mr. Chairman, I move that the board grant the gaming employee occupation permits and non-gaming employee registrations as described by the Bureau of Licensing.
Second.
All in favor?
Aye.
All opposed? Motion's adopted.
There was also a recommendation of denial for gaming employee applicant Latoya Butler. The applicant was notified that she was being recommended for denial and failed to request a hearing within the specified time frame. The Bureau of Licensing has provided you with an order addressing the applicant who the Office of Enforcement Counsel has recommended for denial. I ask that the board consider a motion approving the denial.
Enforcement Council continues to request denial in this instance.
Questions or comments from the board? Hearing none, may I have a motion?
Mr. Chairman, I move that the board deny Latoya Butler's application for a gaming employee occupation permit as described by the Bureau of Licensing.
Second.
All in favor?
Aye.
All opposed? Motion's adopted.
Finally, for your consideration, our gaming service provider registrations. The Bureau of Licensing provided you with an order and an attached list of 2 registered gaming service provider applicants. I ask that the board consider the order registering these gaming service providers.
Enforcement Council has no objection.
Questions or comments from the board? Hearing none, may I have a motion?
Mr. Chairman, I move that the board approve the applications for gaming service provider registration as described by the Bureau of Licensing.
Second.
All in favor?
Aye.
All opposed? Motion's adopted.
That
Thank-
concludes the matters of the Bureau of Licensing.
Thank you, Susan. Cyrus, your people are up now.
All right. The Office of Enforcement Counsel will present 14 matters today for the board's consideration, in which we will request the board's approval of 4 consent agreements, 1 revocation, and non-involuntary exclusions. The next matter on the agenda for the board's consideration is a consent agreement between the Office of Enforcement Counsel and Category 1 licensee Mountain View Thoroughbred Racing Association, LLC, doing business as Hollywood Casino at Penn National Racecourse. The consent agreement will be presented by Deputy Enforcement Counsel Dustin Miller. Representatives from Hollywood Casino are present. At this time, I would request that those individuals introduce themselves for the record, and that anyone not here as an attorney, please stand and be sworn.
Alex Vista, HVI ZDA, Director of Compliance.
Dan Im, IHM, Vice President, General Manager.
Good morning, Chairman Barish, members of the board. Dustin Miller on behalf of the Office of Enforcement Counsel. This consent agreement arises from 4 incidents involving underage violations at Hollywood Casino at Penn National Racecourse. Starting on the night of June 30th, 2018, and continuing into the early morning hours of July 1st, 2018, a 19-year-old individual and a 20-year-old individual entered the gaming floor together. Neither individual was asked for identification. While on the gaming floor, both individuals gamed at various slot machines, and the 19-year-old was served alcohol by two different bartenders. The underage individuals were identified by table games personnel when they sat down at a table game. Both individuals were cited by Pennsylvania State Police and were on the gaming floor for approximately an hour and 34 minutes. On June 29, 2018, a 20-year-old individual was allowed entry to the gaming floor at Hollywood Casino through the valet entrance after providing a fake identification to a security officer. Subsequently, the 20-year-old individual exited the casino and re-entered through the bus entrance. Once again, the 20-year-old supplied the fake identification upon request and was granted access to the gaming floor. While on the gaming floor, the 20-year-old redeemed 2 chips at the cashier's cage. Then the 20-year-old individual exited the casino through the bus entrance and returned to the casino through the racetrack entrance. The 20-year-old individual subsequently observed table game play at 2 different blackjack tables and cashed out $625 worth of chips at the cage without being asked for identification. The underage patron was finally identified as being 20 years old after she left the casino through the racetrack entrance and then tried to re-enter through the same entrance. Pennsylvania State Police confirmed the identification as fake, and the 20-year-old individual was cited for carrying false identification. The underage person was on the gaming floor of Hollywood Casino for approximately 1 hour and entered and exited the gaming floor 3 times during that time. Finally, on August 11, 2018, a 17-year-old used the identification of another person to gain access to the gaming floor of Hollywood Casino. The 17-year-old individual remained on the gaming floor for approximately 1 hour. During that time, the 17-year-old observed his companions engaging in table game play. Eventually, a table games floor person challenged the 17-year-old for identification. The 17-year-old refused to provide the identification and exited the casino. The 17-year-old was apprehended by Pennsylvania State Police and cited for unlawful to permit persons under 21 on the gaming floor of a licensed facility. The Act and Board regulations prohibit underage gaming and also the presence of underage individuals on the gaming floor of licensed facilities. On October 18, 2018, the parties entered into a consent agreement to settle these outstanding compliance matters. The terms of this agreement include a provision that Mountain View Thoroughbred Racing Association, LLC, shall reinforce existing policies to minimize the opportunity for similar incidents to occur in the future. Further, Mountain View Thoroughbred Racing Association, LLC, shall pay a total fine of $40,000 and an administrative fee of $2,500. The fine and administrative fee shall be paid within 5 days of the consent agreement being approved by the board. Counsel for Mountain View Thoroughbred Racing Association, LLC, is in attendance today to answer any questions you may have. Otherwise, the Office of Enforcement Counsel asks the board to entertain a motion to approve this consent agreement.
Any comments from Mountain View, please?
Just briefly, Alex Vizda, Director of Compliance. This is obviously not how we operate our business at Hollywood Casino, and it's not up to our standards. The first thing we did was the employees, some of whom fell far below our standards, we just had to terminate their employment. Others were put on a final written warning and have subsequently, many of them have separated from employment with us. But with regard to our entire workforce, we looked at this and saw that this was the dangers of complacency. We had had a string of successes in June with our customer service scores, our employee engagement scores. Security had just celebrated their first $100 for 100 days of the year. And there was a sense of complacency. So we talked about that as a management team, and in late July when we had our annual responsible gaming refresher, we went over the 2 incidents on June 29th and June 30th in detail with every team member and all the opportunities that we missed and why we can't do that. Going forward in the third quarter of 2018, after we had this discussion, we saw that the number of ID checks increased almost 22% over the prior year. We've had a similar string of success recently with the opening of the sports book, again hitting our customer service scores, and this Saturday opening our new food court venue. And so we actually just celebrated last week. Security had their second $100 for 100 days of the year. But again, these are the same sort of steps that were occurring in June, and so we've had the conversation again with our team members that with all these successes and riding this wave, we have to make sure we don't get complacent going forward.
Any comments from the board on this matter? Hearing none, may I have a motion?
Mr. Chairman, I move that the board approve the consent agreement between the Office of Enforcement Counsel and Mountain View Thoroughbred Racing, LLC, as described by the Office of Enforcement Counsel.
Second.
All in favor?
Aye.
All opposed? The motion's adopted. Thank you for coming.
Thank you. The next two matters on the agenda for the board's consideration are consent agreements between the Office of Enforcement Counsel and Category 2 licensee Mount Airy No. 1 LLC, doing business as Mount Airy Casino Resort. The consent agreements will be presented by Assistant Enforcement Counsel David Tepper. Representatives from Mount Airy Casino are present. At this time, I would request that those individuals introduce themselves for the record, and that anyone not here as an attorney please stand and be sworn.
I do.
Yes.
Good morning, Chairman Barish, members of the board. David Tepper, T-E-P-P-E-R, with the Office of Enforcement Counsel. The proposed consent agreement includes an incident in which Mount Airy violated its beverage service policy. On February 28th, an individual with the initials MG was a patron at Mount Airy and served 8 alcoholic beverages in a 1 hour and 29-minute period by one cocktail server. MG was served 5 beers and 3 shots while he played poker. MG finished consuming his last drink at 2:25 a.m. MG played poker until approximately 5:26 a.m. and from approximately 5:28 a.m. until 7:17 a.m. he played a combination of craps and blackjack. MG departed Mount Airy at approximately 7:28 a.m. after receiving his vehicle from valet attendants. At no time did MG appear visibly intoxicated based upon a review of surveillance footage. At approximately 7:40 a.m., MG was involved in a fatal motor vehicle accident. Since the consent agreement was entered into, MG pled guilty to 1 count of homicide by vehicle while driving under the influence. Prior to
I'm
this,
sorry, can I interrupt you? You said the video surveillance, did he appear intoxicated or not? I didn't
he
hear.
did not.
He did not, N-O-T.
N-O-T.
Okay.
On February 1st, 2017, representatives of Mount Airy appeared before the board regarding a proposed consent agreement for an intoxicated patron involving an incident in which an individual with the initials PS. At that time, Mount Airy's representatives informed the board that if a patron consumed more than 3 drinks in a 1-hour period, a beverage supervisor would be contacted to assess the situation. Then on January 12, 2017, representatives of Mount Airy again appeared before the board in regards to an incident where there was a violation of Mount Airy's alcohol service policy. At that time, Mount Airy advised the board that they purchased BOSS. BOSS is the beverage ordering service system provided by Bally's, which allows Mount Airy to automatically track alcohol service for Mount Airy player card patrons, set minimum time intervals between beverage orders, establish a maximum number of drinks within a set time period, and other beverage service limitations. Furthermore, timely installation of BOSS was a term of the consent agreement between Mount Airy and OEC, which was approved by the board on July 12, 2017. BOSS had not yet been installed by Mount Airy on February 28, 2018. BOSS was installed at Mount Airy in October of 2018. At this time, the Office of Enforcement Counsel requests that the board approve this consent agreement between the parties. The terms of the settlement include that within 5 days of the board's order approving this consent agreement, Mount Airy shall pay a civil penalty of $100,000 for the alleged violations described. Also within 5 days of the board order approving this consent agreement, Mount Airy shall pay the board $2,500 for the costs incurred by OEC, BIE, and other related staff in connection with this matter. If you have any questions, we would be happy to address them at this time.
I have one question. I'm confused by something you said. You said, I guess you're referring to some period back in July of this year, last year, 2017, something about a condition about the, quote, timely installation of the BOSS system. Was there a time limit on what was timely?
There was no time limit expressed in the board's order. However, conversation with counsel from Mount Airy had indicated that the system was in the process of being implemented and contracted. And I believe Mr. Sklar might be.
Well, before you go there, you mentioned a February date. Where did that February date come out with? That it was supposed to be installed by February, or you said something like that.
The February date was the date of the incident. that involved this
Okay.
home service.
Okay, thank you. Is that an accurate description?
That's correct.
Thank you. You have any comments at this time?
I do. Good morning, Mr. Chairman, Commissioners. Michael Sklar, SKLAR, on behalf of Mount Airy No. 1 LLC. With me this morning is Leanne Asbury, Executive Director of Security at Mount Airy, and Mount Airy's new Chief Operating Officer and General Manager, Todd Greenberg. Let me first start off by saying it's obviously very troubling and tragic incident. When Mount Airy was notified of what had occurred, Mount Airy undertook an extensive and exhaustive investigation to learn the facts that took place, that was led by Leanne, and she's going to describe the investigation and findings. After she does that, I'll come back and I'll address the timing with the BOSS system. But first, I'm going to turn it over to Leanne, let her describe the investigation and findings.
Good morning, Chairman, members of the board.
Can I just ask a quick question? Of the three of you, was anybody there in August of 2014? Did you work for the property? You were?
Yes.
Get.
No, ma'am. It's Lianne. Last name Asbury, Asbury. So relative to the incident that did occur with MG in February of 2018, it was once Mount Airy found out about this incident that occurred, I did take the lead on doing the investigation. That included and incorporated working with our surveillance department to track MG, his followings, traversing the property from where he played in poker, blackjack, craps, and upon exiting the property. That was 7 hours of surveillance footage that was viewed of him, playing, watching mannerisms, behaviors, so on and so forth, as well as at 29 different camera angles. With that being said, I did conduct an interview of a variety of different individuals that are employees of Mount Airy, being table games dealers, supervisors, food and beverage personnel, as well as security personnel, that anyone that engaged or had any type of interaction with MG. That was a total of 32 personnel that were interviewed and did provide statements relative to, their findings and what they had relative to their interaction with MG. I will say, based upon the investigation, his last drink service and consumption was at 2:26 in the morning. And we do not obviously run 24/7, so he did not drink anything, to my knowledge, in plain sight, visibly under camera coverage from 2:26 in the morning until he did vacate property at 7:26 in the morning. So there is a 5-hour drag of no type of alcoholic beverages being served to him, hence obviously following suit to the Pennsylvania Liquor Control Board, as well as stopping alcohol at 2:30 in the morning. There's no visual inspection of MG during the course of his time on property when he gets up from the poker tables, and most of the dealers did say that poker players have a little bit of characteristic traits to them. They're obnoxious, they're annoying, they're sloppy, they're messy, so on and so forth. I'll leave those to opinions. But the chairs were kind of they weren't neatly put back to the table. So he was able to traverse around those chairs, go to the restroom, get on the elevator, come down, traverse the terrazzo, sit at blackjack, stand at craps, go to the main cage, as well as, again, traverse through the carpeted area without any type of sway, stagger, any type of visual inspection that would lead someone to believe that that individual was visibly intoxicated. As far as any signs of, further inspection and interview, it is, the consensus that, again, he did utilize the restrooms. He did vacate property, driving on the proper side of the road. And again, I'm not stating that this incident that occurred is not tragic. It is tragic. A life was taken. But I am stating that we did our due diligence in ensuring that we did a full, thorough investigation for this incident.
On February 28th, did a beverage supervisor assess the situation? What's going on?
I'm sorry? Beverage supervisor that I interviewed stopped service in the poker room at 1:30 in the morning from that poker bar. So it would be the cocktail server.
No, I'm not. So you were there in August of 2014, right?
Yes, sir, correct.
So on August 23rd, 2014, a 20-year-old came in, gamed, and for approximately 2.5 hours consumed alcohol, and it was subject of another consent agreement. After that event, back in 2014, what procedures did you change?
From 2014 to current, I know that every pre-shift, it's not just a matter of food and beverage as well as security, it's every pre-shift. For EVS, table games, all departmental personnel that are visibly on the floor working, they are pre-shifting to ensure that anyone that appears, you know, one, as you're mentioning, underage, as well as at the point of intoxication, that they do respond to someone who is ramp certified, whether it be a beverage manager, security, and that we contact surveillance.
So after the February 2017 event, what policies were changed?
The policies after this event here in 2018?
After the 2017 event.
The February 2017.
February 2017 event.
The February 2000.
I know there's a lot of them, but you got to keep them straight for us.
Well, after that event, obviously, you know, we maintain and ensure that ramp certification is up to par upon all the departments that are ramp certified, as well as, again, it is a pre-shift. It's due diligence. It's ensuring that we are watching and monitoring alcohol service. It's a continuous remediation of training. It's very thorough of new hires onboarding. Prior to any new hire onboarding, currently in the table games, as well as security and beverage, they cannot enter onto the casino floor unless they are ramp certified. So that is a huge change for us. Prior to them even entering into their new hire orientation, obviously we ensure that they're licensed, but prior to them entering in their new hire orientation for the property, they do take the ramp certification. So we know that they are certified.
After the February 2017 event, wasn't there a change to that a beverage supervisor would be called to come assess the situation if somebody drank so many drinks in a certain time frame?
That is correct. To my knowledge, again, I don't want to speak on behalf of food and beverage, but I will say that it is an assessment that is made after an hour period of 3 drink service to push to the 4th drink. They do need to have an assessment made.
Okay, so after that February 2017 incident, the person in question, I think, fell off his bar stool, tripped, something happened, and then came back to the property in July of 2017? That same person that had the incident in February of 2017 came back in July of 2017 and had another incident?
You're referencing TS?
I don't have the initials.
That's correct.
We may be a little messed up here on dates.
No,
but we're talking, I just want to,
yeah.
He seems, Mr. Sklar seems a little bit confused. I think we're talking about the 26 drinks and the guy who fell off the bar. Is that what you're talking
That's
about?
the February incident of 2017.
No, I think that was the February. We were here for that first incident on February 2017. I think that the actual incident occurred in, I think it was November of 16.
Okay.
And we came before the board February, and then
17, and that's when you committed to a certain number of drinks in a certain number of time period. A beverage supervisor would come assess the situation. And in that 16 event, that didn't happen.
No.
That's correct.
And then tell me about the July 12th, 2017 incident when it was the same person.
No, that happened, that actual incident that you're referring to, that was the same person, happened that the day they were here at the board meeting.
Got you.
In February, and then for the second February incident, we were here in July before the board.
Okay. So after in the July 12th, 2017, when you committed to the BOSS system,
Right.
what happened? What
Okay. And believe me,
it took a February 2018 incident to get BOSS implemented in, I'm sorry, what did you say, October of 2018?
Right.
So you committed to it in July of 2017. An incident happened in February of 2018.
Correct.
You would think the next day it would be implemented. But it took till October of 2018 to implement BOSS.
Correct.
Even though it was a condition of the consent agreement in 17.
That's right.
Tough to keep these
Let me
incidents straight. I hope you can appreciate that for us.
No, I can, and believe me, I'm not going to sit here and make any excuses. There was a commitment that was made. It was part
Can I
of
just
the-
clarify? That's very helpful. Mr. Sklar, you had indicated you were going to explain the timeline. Is that what you're about to do now? So we all have the same set of
Yes.
facts in front
Yes.
of us?
Commissioner Logan went through the
He
timeline.
went through a lot of
and
it, but
now-
I just want to give you a chance to make sure we're all dealing with the same facts and the same time.
That's the correct timeline. Now I'll pick up as to what happened with the not timely installation of BOSS. So the commitment was made. There's absolutely no excuses that I'm going to give you. I'm just going to give you the facts of what happened. There was, shortly after we were here in July, the executive director of food and beverage and the number 2 in the food and beverage department were terminated. That delayed, they were going to be the ones who were going to shepherd the installation, and it's a process, Commissioner Logan. It's not something you can just say, do it. Bally's has to come in, they got to integrate the BOSS system into ACSC. It's an intensive process, and so it's not just a next day kind of thing. So the 2 terminations occurred. It pushed the Bally's, the BOSS installation back. After that, the John Coletsu, the former general manager, he got terminated, or separated, I should say. Carmelo Segino, who was the replacement for Mr. Coletsu, he was separated. The bottom line is it just fell to the back burner, and once the re-engagement with Bally's occurred, which was around May, June of 2018, you had to get back in the queue with Bally's for them to deploy the personnel necessary. They have to come on site and do all the integration with the systems. That process took a while. It went online for testing in September, but ultimately it didn't go fully.
We'll see if we get a
Hello.
sports bet here.
Okay, we must have dropped the call.
Okay, I'm sorry, please continue.
So, like I said, after the re-engagement with Bally's, it went online for a test period in September, and then it wasn't a go-live until about mid-October of 2018. Again, there's no excuse. There's absolutely no excuse for the significant delay in the installation. I wish I had a better answer for you.
At least you're being honest.
And all I can say is that and I don't want to lay blame, but all of the senior people who would have been involved in ensuring timely implementation are no longer with the company.
I think there's some other questions up here, if we could. Go ahead, Dick.
Yeah, I do have a question, Mr. Sklar.
Sean, did you
No,
want to follow up?
I'm finished, yeah.
This is troubling, and you recognize that. And I'm curious, though, as counsel and the representations made on behalf of your client, the common denominator here over the time, to be very candid, is yourself. Representation being made. Who was tracking the compliance with your representation back here to the board? For example, if somebody was tracking it, at the very least, you'd call Cyrus and say, we got some problems here, what they are, and then you got to work it out, and it may not be a good reason, but he's going to push back, and you're going to be on notice, and things are going to move much quicker. I'm curious as to how that happened, with all due respect, as to yourself as counsel.
The answer is, after the terminations in the food and beverage department, I was told that there needed to be senior people in food and beverage, that it was necessary to have those people in place in order to oversee the implementation and participate in the training. In all candor, it took a long time to find qualified people to come back into those positions. I perhaps, and it's partly my responsibility to communicate to Enforcement Council, which I did not do, and I accept responsibility for that, certainly. Once the food and beverage personnel came back in place, I did re-engage with Mount Airy management, and they said, got it, now we're going to get going on it. And then there was delay. And again, I understand what you're saying, and you are correct. I certainly should have done a much better job of keeping Enforcement Council on the board apprised as the status, and perhaps I should have been a little more, I should have pushed harder on my end to tell Mount Airy management that it was unacceptable, that we understand our responsibilities, and that falls on me.
Thank you. So after the 2016 incident, when you came to the board in February of 2017, you told the board that you updated your internal policies for alcohol service, that if an individual was served 3 alcoholic beverages in a period of 1 hour, then a beverage supervisor would be called to kind of assess, if you will, the situation. Is that still happening?
It is.
Apparently it didn't happen in the July 2017 incident or the February 28th, so how are you fixing that?
It didn't. So the policy for the 3 drinks in an hour, then a notification to a supervisor for an assessment, that was adopted in November of 16. When the February 17 incident occurred, there was a realization that it's difficult to place the onus solely on the servers and bartenders. How they have the ability to track depending on the volumes. How, is it realistic for them to be able to track with certainty? It's not like they have a notepad and they're checking exactly which patrons are having what, how often. That was the notion of the boss, that would assist in the tracking. That was the idea. The policy has been there since November. The difficulty has always been the tracking. How, without some automation, how does a server, a bartender, it's difficult to do that tracking in your brain, even if you were making notations. It's still, and somebody, I don't mean to.
Then how did you commit to the board that would happen if you can't track it?
with the beverage supervisor?
I don't know that the policy exists. I don't know. I don't think we ever said that with absolute certainty. In fact, I think that what was said was we're trying. That's the policy, but there's no ability. Even with BOSS is only going to be effective with patrons who have a player's card. I mean, it's tied to the Bally's ACSC system. If patrons is not playing with a card, BOSS is not going to be the cure-all either.
That doesn't make
I'm
me
sorry,
feel.
can I stop
That
you?
doesn't make me. No, you can't stop me. That
No,
doesn't
I
make.
meant to stop Michael. I'm sorry.
That doesn't make me feel any better. You probably should have stopped 36 seconds ago, because if BOSS is, I'm just looking through here, and we have repetitive events that are involving alcohol and problems. So I am sitting here thinking BOSS, even though it took a long time to implement, hearing that may not solve the problem. I'm not quite sure. At least I don't feel comfortable.
Michael, excuse me just for a moment, because you've made an incorrect statement. The way that BOSS works is that a player may not get a comp drink if they do not use their player's card. So we have implemented it so absolutely everybody has to have a card. So guests who were previously playing without a player's card could no longer get drinks. They had to go and sign up for the player's card.
Free drinks.
In order to get free drinks.
They could still get drinks. They could still buy
They
drinks.
can still get drinks at the bar and at the restaurants.
Yeah, okay, so
but
it's
any of the other players cannot, so you can't come in without a card. You can't get a drink. You have to sign up.
You can't get a free drink.
You can't get a free drink, correct, sir.
Commissioner, I just want to be clear, because I'm glad Todd corrected me. The requirement for, as the casino, it's to prevent intoxicated patrons from getting drinks. The policy that was adopted with the 3 drinks in an hour, that was adopted to try to head off the intoxication getting to that point. It's not that we said that this is going to cure, the service of intoxicated patrons. It was a policy that was implemented that we thought was reasonable and logical to start making the assessments early on. That once you start getting more than 3 drinks in an hour, that timeout, there needs to be an assessment. Not that there's an automatic shut-off. It's just that a supervisor should come, make an assessment. If there's no signs of intoxication, the policy is not that absolutely they don't get a drink. It's just that an assessment is made.
Okay. And if I could, I have a comment, but I just want to clarify something for the record. There's a lot going on here. You just have to be clear when you say you can't get a drink. That's not what we're talking about. You can't get a free drink.
Correct.
Incredibly important distinction, and I don't want the record to be confused in any way about this. And I got to say, listening to all this, and I'm not going to jump up and down and blame people and ask somebody individually. It's the entity that's responsible here. You had over a year. In recognition of a very serious problem, you committed to do something, and if I got it right, it took you a year and a half to accomplish it. I guess it's not a priority. I don't know what, it's not a matter of whether you forgot to tell somebody. You have some serious problems there. Steps are taken. They may not have solved everything, but they would have helped. And apparently, it wasn't a priority because it doesn't take, I don't care who left and who came. It doesn't take 18 months to install this thing. And what does it happen? It happens, what, a month ago? After we're talking about this in consent orders and discussions with OEC a year and a half ago? I just find that outrageous and unacceptable, period.
Mr. Chairman, if I'm correct, on the February 28th, 2018, if MG did not have a player's card, the BOSS system doesn't even track it.
That's correct.
Should you guys go back to the drawing board to find out another system? I'm just saying, so if I go in and I don't have a player's card and I pay cash for my drinks, you're now reliant on what you committed in the February 2017 meeting, that if somebody serves me 3 drinks over an hour, somebody that you basically said may, I don't want to put words in your mouth, may or may not have the skill set to assess if I'm intoxicated, that's what you're going to rely on now, because I don't have a player's card, so BOSS doesn't impact me.
No. I want to be clear. Not that the skill set isn't there, because all servers and bartenders are RAM trained.
Okay.
So it's another set of eyes was the reason for the policy with the 3 drinks. Just another set of eyes, not that everyone's RAM trained. Everyone should have the experience and the ability to make the assessment on their own.
Did the gentleman have a card?
Yes, yes, he did.
If there aren't any other questions or comments, is there a motion?
Mr. Chairman, I move that the board reject the consent agreement between the Office of Enforcement Counsel and Mount Airy No. 1 LLC as described by the Office of Enforcement Counsel.
Second.
All in favor?
Aye.
Aye. All opposed?
No.
Okay, the motion's adopted. The motion to reject is adopted. Okay. Is that accurate, Doug? Thank you. Let's go on to the next one, please.
The next proposed consent agreement includes 17 incidents of underage access gaming and/or alcohol consumption at Mount Airy Casino, which occurred between 2016 and 2018. In each of these instances, an individual under the age of 21 gained access to the gaming floor, placed wagers on either slot machines or table games, and/or consumed alcohol. The underage individuals ranged from 12 years of age to 20 years of age. In the first count, on July 16, 2016, a 17-year-old male gained access to the gaming floor and remained on the gaming floor for approximately 41 minutes. During that time, he placed wagers at table games for approximately 35 minutes. In the second incident, on February 12, 2016, a 19-year-old male gained access to the gaming floor, and between February 12th and February 13th, he spent an aggregate of 6 hours and 3 minutes on the gaming floor. During this time, the individual placed wagers at table games for approximately 3 hours and 56 minutes. The individual did not consume any alcoholic beverages.
In the first instance, did the individual consume alcohol?
No.
In the second, no?
No. Okay. On May 28th, 2016, a 20-year-old male gained access to the gaming floor between May 28th and May 29th, spent on 3 different times an aggregate amount of 16 hours and 32 minutes on the gaming floor. While on the gaming floor, the underage individual spent approximately 5 hours and 32 minutes playing a combination of slot machines and table games and consumed 7 alcoholic beverages. In the fourth incident, on July 3rd, 2016, a 20-year-old male and a 19-year-old female gained access to the gaming floor. These individuals were on the gaming floor for approximately 18 minutes. The female did not wager, and the male played table games for 13 minutes. On November 3rd, 2016, a 20-year-old male gained access to the gaming floor. The individual was on the gaming floor for approximately 7 hours and 17 minutes. The 20-year-old male placed wagers at table games for 3 hours and 33 minutes. On December 21st, 2016, a 20-year-old male gained access to the gaming floor. The individual was on the gaming floor for 52 minutes and placed wagers at slot machines for 41 minutes. The individual consumed 1 alcoholic beverage. On January 11th, 2017, a 20-year-old male gained access to the gaming floor. Between January 11th and January 12th, the individual spent an aggregate of 9 hours and 37 minutes on the gaming floor, placed wagers at table games for 3 hours and 9 minutes, and consumed 6 alcoholic beverages. On February 17th, 2017, a 20-year-old male and a 20-year-old female gained access to the gaming floor. Between January 17 and February 18, the male spent an aggregate of 5 hours and 56 minutes on the gaming floor and placed wagers at table games for 5 hours and 34 minutes. The male consumed 1 alcoholic beverage. The female was on the gaming floor for an aggregate of 5 hours and 22 minutes and placed wagers at table games for 5 hours and 6 minutes. In the 9th incident, on March 25, 2017, a 20-year-old male gained access to the gaming floor. The individual remained on the gaming floor for 39 minutes and placed wagers at table games for 19 minutes. On April 8, 2017, a 20-year-old female gained access to the gaming floor. Between April 8th and April 9th, the individual remained on the gaming floor for an aggregate of 5 hours and 34 minutes and placed wagers at slot machines and table games for 34 minutes. The individual consumed 3 alcoholic beverages while on the gaming floor. On January 23, 2017, a 19-year-old female gained access to the gaming floor. The individual remained on the gaming floor for 34 minutes and placed wagers at a hybrid table game for 29 minutes. On July 30th, 2017, a 20-year-old female gained access to the gaming floor. The individual remained on the gaming floor for 9 minutes and placed wagers at table games for 3 minutes. On August 7th, 2017, a 20-year-old female gained access to the gaming floor. The individual remained on the gaming floor for an aggregate of 1 hour and 3 minutes and placed wagers at table games and slot machines for 26 minutes. The individual consumed at least 1 alcoholic beverage while on the gaming floor. In the 14th incident, on October 21st, 2017, a 12-year-old female gained access to the gaming floor. The individual, along with her grandmother, remained on the gaming floor for 35 minutes. The 12-year-old is believed to have operated the slot machine. On December
12-year-old drink?
The 12-year-old
You don't have to answer it.
No, thankfully not.
On December 27th, 2017, a 20-year-old gained access to the gaming floor. The individual remained on the gaming floor for an aggregate of 3 hours and 14 minutes, placed wagers in slot machines and table games for 1 hour and 33 minutes. The individual consumed 2 alcoholic beverages while on the gaming floor. In the 16th incident, on January 11th, 2018, an 18-year-old male who was an off-duty Mount Airy employee gained access to the gaming floor. The individual remained on the gaming floor for an aggregate of 1 hour and 9 minutes and placed wagers at slot machines for 9 minutes. After being identified as underage and escorted off the gaming floor, the individual gained access to the gaming floor 3 additional times. While on the gaming floor, the individual consumed 2 alcoholic beverages. In the 17th incident, on July 18th, 2018, a 20-year-old male gained access to the gaming floor. The individual remained on the gaming floor for 45 minutes and placed wagers at table games for 36 minutes. At this time, the Office of Enforcement Counsel requests that the Board approve this consent agreement between the parties. The terms of the settlement include that within 5 days of the Board's order approving this consent agreement, Mount Airy shall pay a civil penalty of $170,000 for the alleged violations described. Also within 5 days of the Board's order approving this consent agreement, Mount Airy shall pay the Board $2,500 for the costs incurred by OEC, BIE, and other related Board staff in connection with this matter. If you have any questions, we would be happy to address them at this time.
I don't even know where to start with that. I guess the only place go ahead, I'm sorry.
Just for process, first we hear from Mount Airy, and then I'll open it up for questions. Mr. Sklar.
I'm just going to have Leanne briefly address these overall. I don't know that we'll answer questions on specific incidents, but she's going to, I think, address more globally the security and underage. I just want to make sure everyone understands that this is over a 2.5-year period.
Yes.
Yeah.
Chairman and members of the board, relative to the 17 incidents that did occur over the 2.5-year period, I do obviously as Executive Director of Security take onus and responsibility under my security department for identifying anyone that does appear to be under 30 as well as anyone that appears to be under 21 and refuse their access to the gaming floor. Clearly, on 17 instances and occasions, we did fail on those levels. However, I will state, before I bombard you with any type of statistical information, I will state that over 4 million individuals did access Mount Airy through that period from 2016, 17, and currently 18. Of that, we had 78,300 307 minors that accessed during that period that were not allowed access to our casino floor. I will also advise that of that, 17 incidents here, we did have 11 of them utilize fake or false IDs, whether it be their siblings, relatives, cousins, friends, so on and so forth. One that actually did unfortunately use their own ID and was subsequently caught at the main cage cashing in the chips and owned up to, hence being under 21. Another fake ID was a 2-for-1 deal in an incident situation because our monitor froze, and we did go to the handheld. With innovative technology, unfortunately, handheld scanners are just not that innovative yet. They're not up to par with the software. We are still working on revamping that. However, we have reinvested in Mount Airy security as well as on this property over $30,000 into a highly innovative and technological computerized system at our entranceways that scans the ID. It will perform the risk factors that realistically it would be operator error. And unfortunately, we did have some operator errors. But this innovative technology by far, and I know that some of the casino compliance representatives as well as our state police on site have said, I think Mount Airy has to be the casino that has the most fake and false IDs that you guys are catching. So I will say on that note, that is a good thing for us. We did reinvest in our department as well as this type of technology. We also do remedial training for identification checks, scanners, handhelds, the UV lights, the whole gamut when it comes down to identification checks in order to ensure that we are refusing anyone that appears to be under 21 admittance into the casino. With respect to these 17 incidents, I will speak on the 7 termed employees. I will speak on 1 suspended employee and 9 final warnings that were issued. Subsequently, also, of those 9, I believe only 4 remain as employees. They have since departed our property. Our policies and procedures relative to minors and incidents such as these is we do allow families to be entertained on our property, and we do provide escorts. That was implemented in another compliance and consent agreement years back, and we have maintained that. We do fully understand the responsibility of ensuring that minors do not gain access to our casino floor. We also understand that with our due diligence of allowing families to come to our property and putting another layer up to notify our dispatcher to log that last name of that family member that takes onus of that under 21 individual to that dining establishment, that if unfortunately they would end up on the casino floor, we would be able to have that substantial information. We have done really well with providing those escorts as well as those left-handed wristbands that are bright neon yellow. If you've had the opportunity to visit our property, anyone that is under 21 is identified. And also, if they do not have the most appropriate ID that we accept on our property, is issued that wristband. We do have a curfew implementation as well. The curfew implementation, in order to deter these wild, outrageous hours of, minors trying to get into the casino is, Fridays and Saturdays, we implement curfew at midnight. Anyone that's under 21 can remain in the lower lobby, whether it be through bus until they depart, or if they are a hotel guest. They cannot go to any type of dining establishment, even if it is one of our 24/7 establishments. They have to order, if they're a hotel guest, they would have to order room service. We would not provide an escort. During the weekday, Sunday, obviously through Thursday, our escort implementation starts at 10 p.m. and it doesn't reconvene until 7 a.m. So we are working feverishly as well as continuously to deter this underage gambling issue as well as problem.
Thank you. At this point, I'd open up to questions or comments from the board.
I'll defer to the cat first this time.
I just want to understand the 12-year-old incident. Did Grandma hide her under the coat? Clearly, a 12-year-old, unlike an 18 or 20-year-old, isn't carrying a false ID and isn't being mistaken in terms of her age at a screening point. So it leads me to believe somehow she was able to get on the floor without going through any kind of security checkpoint. How does that happen?
To speak on the note of the 12-year-old incident, yes, it is an embarrassment. I will say that through surveillance footage and reviewing of the footage, it was pre-planned for the grandmother as well as the grandmother's boyfriend to get the 12-year-old on the floor. They waited for the security officer to move over to the scanner. He motioned with his cane to go over this way because he saw the opening. It was a Saturday, mid-afternoon, early evening time period, a lot of volume coming through. They saw their breakaway, and they went to slot machines that are against a wall where you would not have face-to-face interaction per se with somebody unless you hit your service button to have them come over. I was there for that incident. When I did engage with the grandmother, I did ask her, I said, really, what was the reasoning to have your 12-year-old on our gaming floor?
So it's not like there was a way that someone could get on the floor without getting through a checkpoint. They just figured a way, your testimony is they figured a way to kind of elude the checkpoint.
100% yes.
Commissioner, can I just add to that? Because I agree, and I asked for them to burn the surveillance on a disk and send it to me, because it's kind of shocking how 12-year-olds like sticking out like a sore thumb. How is it even possible? They literally, the grandmother and the boyfriend, literally, and you could see them kind of talking how to do it. They tucked the 12-year-old on the opposite side of the security checkpoint. When they went through the checkpoint, the area where they went in, you can make a quick right, and there's a bank of slot machines against the wall. They faced that bank the entire time. There wasn't a lot of personnel, moving around, because again, it's a 12-year-old. I mean, it's not, a 19-year-old. So, I mean, this was clearly a calculated thing to purposefully evade the detection.
Were those grandparents banned?
I'm sorry?
Are the grandparents banned?
Oh, absolutely.
For how long?
Forever.
How long was the 12-year-old on the floor?
35 minutes, ma'am.
You got other questions?
Yeah, I'm still hung up on the alcohol, but so of the 17 incidents that were in that 2.5-year period, I lost track. How many involved alcohol?
Roughly, I think it's around 22 alcoholic drinks that were served. One instance was 7. I think another one was 6.
One was 2.
To all minors.
To all
So the
underage.
BOSS system that was implemented.
Oh, it wasn't implemented.
No, I know. It's the BOSS system that was implemented in October of this year. It wouldn't have impacted any of those.
No. I doubt they had
Because they didn't have players' cards, they didn't. So you still see there's still. I'm having a hard time. Go ahead, I'm sorry.
It would have actually impacted them because they wouldn't have been served a drink if they didn't have a card.
But they could pay. They obviously paid for it.
No, they were given complimentary.
But they were getting complimentary drinks.
Okay.
Anything else, Sean?
No.
Okay.
I just have one question. So if somebody comes into your hotel and has a family with them, is the casino notified? Is there any communication between the hotel and you because you have Kalahari and all that up there now, or no?
Well, Kalahari doesn't have anything to do with Mount Air, but
No,
I will say...
I'm just saying because
our
people would stay at your hotel to go to Kalahari.
Sure. Our hotel, on our hotel folios, when they come in with their reg card, there is, our curfew policy as well as the implementation of the wristbands and escorts that are provided for anyone that's under 21 to ensure that they understand that if they have minors with them, these are the policies and procedures that they have to abide by.
I'm sorry. To clarify, where are we? Were there any other questions up here?
Can I just make one more comment? And,
Sure.
And this is for, I guess, for the legislature, and I've said this before the board before. The problem with underage gaming, no casino, including Mount Airy, wants their business. I mean, this is not, we'll turn a blind eye because we're going to generate some revenue. No one wants the underage on the floor. Part of the problem in Pennsylvania is there is no significant deterrent for the minors. It's a misdemeanor, it's a small fine, it's just not a disincentive for the minors. They're going to try, and unfortunately, the reality is, and I'm not shifting blame, we're accepting responsibility. It's never going to be foolproof. It's not going to be at Mount Airy. It's not going to be at any casino because the minors are going to try. In New Jersey, they have instituted a significant penalty where you lose your driver's license for a period of time.
Sounds like you were once a minor.
It's frustrating, I think to Mount Airy and probably I know the other casinos. We've had conversations. It's a difficult thing it's strict liability, so everyone's going to have to accept responsibility for minors getting in. But it's a problem that I don't know how it's ever going to be solved until there is really a disincentive where the minors say, you know what, it's not worth it. It's not worth me taking a chance where I could potentially lose my license. That's a penalty. What's in place right now, it's not much of a disincentive.
Is there a motion at this point? Oh, I'm sorry. Was there another question? Jen? No? Yes? No. Okay. I'll take a motion.
Mr. Chairman, I move that the board approve the consent agreement between the Office of Enforcement Council and Mount Airy No. 1, LLC, as described by the Office of Enforcement Council.
Second.
All in favor?
Aye.
Any opposed? Motion's adopted.
Thank you.
Thank you.
Next matter on the board's agenda for consideration is a consent agreement between the Office of Enforcement Council and gaming permittee identified as RN. The consent agreement will be presented by Assistant Enforcement Counsel Thomas Monahan.
Good afternoon, Thomas Monahan with the Office of Enforcement Counsel, MONAGHAN. At this time, the Office of Enforcement Counsel has a consent agreement prepared for the board's consideration. Consent agreement is between the Office of Enforcement Counsel and RN, a gaming employee occupation permit holder, who was also on the PGCB self-exclusion list, in which he placed himself on in April of 2014 for a period of 5 years. This consent agreement arises from an incident that occurred at Lady Luck Casino Nemacolin on August 25, 2017. RN gained access to the gaming floor at Lady Luck and wagered at table games. On or about September 3rd, 2017, during a compliance review for unrelated investigation, it was discovered that RN is on the board's self-exclusion list. RN was on Lady Luck's gaming floor for approximately 3 hours and 48 minutes and actively wagered at 6 different table games. Due to RN's actions at Lady Luck, the Pennsylvania State Police cited him with trespass. This consent agreement represents the second known self-exclusion violation of RN since his licensure. RN violated the self-exclusion program on January 22, 2016, and entered into a consent agreement in March of 2016, accepting a 5-day suspension for his violation. The board issued an order adopting the consent agreement in May of 2016, and RN served that suspension, and the suspension was lifted in June of that year. By placing himself on the self-exclusion list, RN acknowledged that if he is discovered on the gaming floor at any licensed facility, that he will be subject to removal and arrested for criminal trespass. Due to RN violating the terms of the self-exclusion program and for being cited for trespass, OEC and RN entered into a consent agreement whereby RN's gaming employee permit be suspended for a period of 10 consecutive days from the date that the board approves this consent agreement. At this time, the Office of Enforcement Counsel requests the board approve this consent agreement and are available to answer questions you may have at this time.
Thank you. Questions or comments from the board? Hearing none, may I have a motion?
Mr. Chairman, I move that the board approve the consent agreement between the Office of Enforcement Counsel and RN as described by the Office of Enforcement Counsel.
Second.
All in favor?
Aye.
All opposed? The motion's adopted.
Next matter on the agenda consists of an enforcement action in which the Office of Enforcement Counsel filed a complaint seeking the revocation of a gaming employee occupation permit issued by the board. The complaint has been filed with the board's Office of Hearings and Appeal and properly served upon the person named in the complaint. The person named in the complaint failed to respond within 30 days as required by board regulation. As a result, the Office of Enforcement Counsel filed a request for default judgment and properly served the same upon the named person. Therefore, the facts in the complaint are deemed admitted. All filed documents have been provided to the board, and the matter is presently ripe for the board's consideration. Mr. Tepper will provide a brief summary of the facts and request the appropriate board action.
Good afternoon. Next on the agenda is a complaint to revoke the gaming employee occupation permit of Robert Sharp. Mr. Sharp, while on duty as an employee at Parks Casino, made threats to cause extreme bodily harm to his supervisor. As a result of his conduct, Mr. Sharp was terminated by Parks and criminally charged by the Pennsylvania State Police. At this time, the Office of Enforcement Counsel requests that the board revoke the gaming employee occupation permit of Robert Sharp.
Questions or comments from the board? Hearing none, may I have a motion?
Mr. Chairman, I move that the board approve the revocation of Robert Sharp's gaming employee occupation permit as described by the Office of Enforcement Counsel.
Second.
All in favor?
Aye.
All opposed? The motion's adopted.
The remaining matters on the agenda consist of enforcement actions in which the Office of Enforcement Counsel filed petitions seeking the involuntary exclusion of individuals whose presence in a licensed facility are inimical to the interests of the Commonwealth and are licensed gaming therein. In each instance, the petition for exclusion has been filed with the Board's Office of Hearings and Appeal and properly served upon the individual named in the petition. The individual named in the petition failed to respond within 30 days as required by board regulation. As a result, the Office of Enforcement Counsel filed a request for default judgment in each instance and properly served the same upon each named individual. Therefore, all facts in each petition are deemed admitted. All filed documents have been provided to the board, and the matters are presently ripe for the board's consideration. In each instance, if the board orders the proposed exclusion, each individual's photo, personal identifiers, and a summary of their inimical conduct will be placed on the board's public website.
Good afternoon, Mr. Chairman and Commissioners. Ashley Gabriel, Gabrielle. The next matter on the agenda for the board's consideration is a petition for the exclusion of Jason Sandow. Mr. Sandow attempted to buy in at a roulette table at Parks Casino with 3 counterfeit $10 bills and purchase food in the food court with 2 counterfeit $20 bills. Mr. Sandow possessed an additional 58 counterfeit bills, 57 $10 bills, and 1 $20 bill. Mr. Sandow was criminally charged as a result of his conduct, and Parks elected to permanently evict him. At this time, the Office of Enforcement Counsel requests that the board exclude Jason Sandow.
Questions or comments from the board? Hearing none, may I have a motion?
Mr. Chairman, I move that the board approve the addition of Jason Sandow to the PGCB involuntary exclusion list as described by the Office of Enforcement Counsel.
Second.
All in favor?
Aye.
All opposed? Motion's adopted.
The next matter on the agenda for the board's consideration is a petition for the exclusion of Gary St. John. Mr. St. John cashed a voucher that did not belong to him worth $745, representing the credits left on a slot machine by a patron at Parks Casino. Mr. St. John did not make restitution to the patron. Mr. St. John was criminally charged as a result, and Parks elected to permanently evict him. At this time, the Office of Enforcement Counsel requests that the board exclude Gary St. John.
Questions or comments from the board? Hearing none, may I have a motion?
Mr. Chairman, I move the board approve the addition of Gary St. John to the PGCB involuntary exclusion list as described by the Office of Enforcement Counsel.
Second.
All in favor?
Aye.
All opposed? The motion's adopted.
Good afternoon, Chairman, members of the board. Benjamin Farrell, Ferrell. The following six matters regarding petitions to place Tuan Dang, Cam Hang, Duong Su, Min Win, Zong Wang, and Jun Zhang on the exclusion list come from the same fact pattern. Between December 1st and December 8th of 2017, 3 Harris Philadelphia table game dealers, Tuan Dang, Cam Hang, and Duong Su, colluded with 7 patrons, including Min Win, Zong Wang, and Jun Zhang, to cheat during midi baccarat play at Harris Philadelphia, which resulted in a total loss of $831,650 to Harris and resulting tax revenue to the Commonwealth. All individuals have been charged criminally, and those charges remain pending. Harris Philadelphia permanently evicted all of the individuals from its facility. At this time, OEC first requests the board issue an order placing Tuan Dang on the involuntary exclusion list.
Before we get that, we're going to deal with your fact pattern. Is there any questions that anybody has about the underlying fact pattern in these cases?
Oh, wait, what again? I'm sorry.
Hearing No questions. Now,
Isn't it Dong Su?
I think the first one
Oh,
is
it's
Dong
Dong
Su.
Su.
He said Tuan Dang, and I think it's Dong Su. We
Yes,
deal with
that's
those.
correct.
let's start with that.
Yep.
Hearing no questions about the or comments about the underlying fact pattern, may I have a motion relating to Dong Su? Who has the Dong Su motion?
Merit.
Oh, got it. Okay.
Mr. Chairman, I move that the board approve the addition of Dong Su to the PGCB involuntary exclusion list as described by the Office of Enforcement Counsel.
Is there a second?
Second.
All in favor?
Aye.
All opposed? The motion's adopted. What's the next one?
Yep. Now, at this time, OEC requests the board issue an order placing Tuan Dang on the involuntary exclusion list.
Questions or comments from the board? Hearing none, may I have a motion?
Mr. Chairman, I move that the board approve the addition of Tuan Dang to the PGCB involuntary exclusion list as described by the Office of Enforcement Counsel.
Second.
All in favor?
Aye.
All opposed? The motion's adopted.
And at this time, OEC requests that the board place Cam Hang on the involuntary exclusion list.
Questions or comments from the board? Hearing none, may I have a motion?
Mr. Chairman, I move that the board approve the addition of Cam Hang to the PGCB involuntary exclusion list as described by the Office of Enforcement Counsel.
Second.
All in favor?
Aye.
All opposed? The motion's adopted.
At this time, OEC requests the board issue an order placing Win-Win on the involuntary exclusion list.
Questions or comments from the board? Hearing none, may I have a motion?
Mr. Chairman, I move the board approve the addition of Min Wing to the PGCB involuntary exclusion list as described by the Office of Enforcement Counsel.
Second.
All in favor?
Aye.
All opposed? The motion's adopted.
At this time, OEC requests the board issue an order placing Zong Wang on the involuntary exclusion list.
Questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board approve the addition of Zhong Wang to the PGCB involuntary exclusion list as described by the Office of Enforcement Counsel.
Second.
All in favor?
Aye.
All opposed? The motion's adopted.
At this time, OEC requests the board issue an order placing Jun Zhang on the involuntary exclusion list.
Questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board approve the addition of June Zhang to the PGCB involuntary exclusion list as described by the Office of Enforcement Counsel.
Second.
All in favor?
Aye.
All opposed? The motion's adopted.
The next matter for consideration is the petition to place Christopher Jones in the exclusion list. On August 1st of 2018, Mr. Jones attempted to steal $2,000 in chips from Harris, Philadelphia. Mr. Jones was charged by the Pennsylvania State Police with 2 theft-related misdemeanors and 1 summary offense. Those charges remain pending. Additionally, Harris, Philadelphia issued Mr. Jones a permanent eviction notice from its facility. At this time, OEC requests that the board issue an order placing Christopher Jones on the involuntary exclusion list.
Questions or comments from the board? Hearing none, may I have a motion?
Mr. Chairman, I move that the board approve the addition of Christopher Jones to the PGCB involuntary exclusion list as described by the Office of Enforcement Counsel.
Second.
All in favor?
Aye.
All opposed? The motion's adopted.
Thank you. That concludes our business. Happy holidays to everyone.
Thank you all. Same likewise. This time we have a scheduled public comment period. As I understand it, we don't have anyone in the general public who wishes to address the board at this time. Is there anybody here that we've missed somehow? If not, this concludes today's meeting. Our next scheduled public session will be held on Wednesday, January 9th at 10 o'clock in this room. May I have a motion to adjourn?
So moved.
Second.
All in favor?
Aye.
All opposed? The motion's adopted and we are adjourned. Thank you all for your time and your patience.